The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good afternoon. 2 cases will be submitted. Those cases are Jeffrey Anderson versus Anderson Tooling, Dean Anderson and Carol Anderson. And the second case is State of Iowa versus Lloyd Ashbrenner. We'll now hear the arguments in Anderson, and Mr. Ballard, you may proceed.
May it please the court? Counsel? It's the older I get, the more I realize the honor it is to address the Supreme Court. I'm happy to be invited to do so. My wife and I have been married for 22 years, and we've been together quite a bit longer than that. It took me a while to convince her. And she said to me last week, "I've never seen you in court. Maybe I should come to your Supreme Court argument." And I said, "Well, let me tell you a little bit about what further review is and what could be the issues and what may be the issues. And maybe you could come a time when I know what the issues are going to be, and maybe not on Tuesday. So Jennifer will come another time." Your Honors, the court should reverse the Court of Appeals decision here principally for 2 reasons. In this case, the Court of Appeals misapplied Iowa's concerted liability law and frankly failed to consider all the jury instructions together. Concerted liability is not a foreign concept to the law. It's not a foreign concept to humanity. Generally, I think the notion that a person is responsible for the person's conduct is well accepted. I think the law, and I think real life, if you will, looks differently when someone is trying to apply liability against someone for what another party did. But the law of Iowa is clear that concerted liability, principally under the Restatement Second of Torts, Section 876, has been long applied, long recognized. In this case, the jury heard about not quite 5 full weeks, but it was spread over 5 weeks of testimony. Every case, I think, credibility is an issue, and it was certainly a big issue in this case. The jury found in this case that there was no agreement between Jeff Anderson and ATI based on Jeff's claims, but that Jeff had committed the torts of breach of fiduciary duty and interference with prospective business relationships, and awarded $776,000 as a consequence. The jury also concluded that Lori and Fabcon, Jeff's company, conspired with Jeff to harm ATI, and on that basis, the district court found Jeff to be jointly and severally liable with Lori and Fabcon.
Here's the problem I have is I don't agree with the Court of Appeals. I don't think that 0 is the appropriate number to award against Lori and Fabcon, because the jury said 0 duplication. But how do we know that $777,000 is the appropriate number to award against Lori and Fabcon? I mean, you let the jury go. I mean, that was one of the options. Judge Gookin said, do we need to ask them about anything? And I think both sides said, no, let them go and we can deal with it in post-trial motion. So how do we know what 0 duplication really meant?
Well, Your Honor, I think we know what 0 duplication meant because it's what the jury said. Now, I don't mean to be flip about that at all, but that is what the jury said, 0. You know, a record is important to a trial lawyer, and after you live with the record and then you look at it and then you have an appeal and you have a little time and you look at it, 15 or 45 more times, you say, I don't know what would have happened if the jury would have put a number on that line for what were the damages caused by the conspiracy. Because in fact, as the case law is pretty clear, conspiracy of itself isn't an actionable tort. It's a method for imposing vicarious liability. And I mention that because the jury did say, no, we followed the instructions. We're not going to award any duplication. So how did we know that the jury wanted Lori and Fabcon liable for the full $776,000?
I think you've restated my question nicely.
Thank
So
you.
why don't you answer?
Fair enough. I think the answer is that it's not the jury's charge to say what amount of damages resulted from the civil conspiracy. It was a question of law for the court based on the evidence.
Oh, but the scope
Given-
of the civil conspiracy might not have covered all the breaches of fiduciary duty that, Mr. Anderson was allegedly involved in. I mean, the jury could have concluded that, well, as to this prospective business advantage and that prospective business advantage, there was a conspiracy, but with respect to 3 or 4 others, there was not.
I guess what I would say, Your Honor, and I hope this answers Justice Mansfield's question as well. I mean, the verdict form, the jury was, and the instructions, the jury was instructed that a conspiracy involves an agreement to harm ATI, and that to find that conspiracy, first, the jury had to conclude that Jeff committed one of these harms, and then that ATI was damaged. So I think the answer is, when the jury says there was the agreement and there was concerted action to harm ATI, I think the nature of vicarious liability is that the co-conspirator is liable for the whole shooting match.
Anything within the scope of the conspiracy, once again, we don't know exactly what the scope of the conspiracy was, I take it.
In some ways, we don't, I guess. The evidence was that husband and wife were both employees of ATI for many years. It's a small town, it was a small company. They worked hand in glove, hand in hand with each other the whole time. The evidence was that Jeff diverted jobs that belonged to ATI to the company Fabcon, and that Lori helped with that diversion, okay?
Didn't the jury tell us what the scope of the liability or the conspiracy was, that it was to appropriate funds and projects that belong to Dean Anderson?
To ATI? I think that's right, Your Honor. And I think the other instructions, contrary to what the Court of Appeals found, didn't limit funds and projects that belong to ATI to necessarily things that were right in front of ATI at the moment. And I'm not sure if this is Your Honor's question, but, the Court of Appeals said, well, a prospective business relationship doesn't belong to ATI presently. And my answer to that would be, well, the opportunity to have that relationship belongs to ATI presently, and that's the basis of the tort. Not that you took something out of my pocket right now, but you took my chance to put something in my pocket. That's the tort. That's what ATI was deprived of. The other thing I would say is, with respect to many of the underlying theories of recovery and facts supporting them, for example, and this isn't in the Court of Appeals decision, but Jeff Anderson flat out took dollars that were paid to his company Fabcon as part of an insurance claim and didn't pay them over to ATI, which he agreed to do, which he was supposed to do. That was part of the conspiracy. Lori was involved in sending the invoices. Lori was involved in doing the accounting. Lori was involved in using her email address at ATI to direct ATI customers over to Fabcon. Lori did all of that, okay? Talk about scope of the conspiracy, what damages really resulted. At the end of the day, what happened was Jeff got fired from ATI and decided to sell Fabcon, his fabrication business. He went down the street to a company that had various businesses dealing with metal fabrication and the like, Schaus Voorhees, and Greg Voorhees testified at trial, and he said, Jeff asked me if I wanted to buy his fabrication business. I took one look at the books, and I said, you don't have any fabrication business, but you have a rigging business, the very kind of business that Dean Anderson and ATI told Jeff you can't do. And at the end of the day, that competitor down the street became a competitor in the rigging business, which it had not been, because Jeff sold the assets of Fabcon. Okay, Jeff sold the assets of Fabcon. Lori owned none of those assets, but he sold them to Schaus Voorhees, and at the end of the day, Lori, without having any ownership of the assets sold and without making any capital contribution, became a 25% shareholder in this Schaus Voorhees company, the competitor down the street. And I say that because, as I started, 5 weeks of trial, and the jury heard all of that. So what was the scope of what did Lori really do to participate? She did everything to participate, and I think the jury heard that.
But it still gets back to the question for me that I raised, and I think Justice Apple raised. I mean, isn't it, as to Jeff, the jury awarded $777,000 in damages for a variety of things that Jeff did. Isn't it possible that the jury found that the conspiracy related to some of those things, but not all of them? And how do we know that without a number attached to their verdict?
I guess the first thing I would say is what I've tried to say. I think that the jury wasn't asked, which damages that Jeff caused, that you've awarded, did Lori participate in the conspiracy? The jury was asked.
Sure they were. There was a line that said damage from the conspiracy.
There was, but they said nothing further. They didn't say nothing at all. They said nothing further, duplication.
Sure, but that could have been 250 or 400 or any, it is.
It could have been, but it wasn't. They didn't say that. The second thing I would say is, as Justice Mansfield pointed out, Judge Gookin got on the phone. We've got a verdict. Here it is. You want us to keep the jury? No, okay, it's over. But then there was an opportunity on a post-trial motion to say, hey, Judge, you sat here and listened to this evidence, and you should apportion this conspiracy verdict, or you should make some determination, and that wasn't requested. In our mind, when the jury said, Lori, you conspired, and I keep saying this, but 5-week trial, based on the evidence, based on everything the jury heard, Lori, you conspired all the way, hand in glove, step by step with Jeff, so you're responsible for everything. It's a finding as a matter of law, to assess joint and several liability, not a finding to assess additional damages to Lori for a conspiracy. In our view, there's ample evidence to show that Lori not only agreed to harm ATI, as the jury found, but also that she knew Jeff was avoiding or was disregarding duties that he had. They both admitted that they were fiduciaries. The jury found that Jeff breached his fiduciary duty, found that Lori didn't breach her fiduciary duty, but the jury did find that Lori agreed to harm ATI and that she took conduct to harm ATI. We don't think that there's really any way for the jury's decision. The jury didn't award ATI all of its damages, but it awarded a substantial number, okay? And we think that our evidence shows that Lori participated step by step, as I say, in helping Jeff do all of that. And as I said, at the end of the day, helping him sell his company and her becoming a beneficiary of that sale, even though she didn't really have anything at all to do with it. I think it's important, I'm a believer in the jury system, and even when it doesn't go your way, I'm a believer in the jury system. And I think it's important here to recognize that this jury wasn't, in love with my clients. This jury awarded damages in favor of Jeff, and it awarded substantially more damages in favor of my clients. But, you never say never. I don't know if I'll try enough cases or live long enough to find another jury, and I'm trying to find this on the verdict form, even though I know what it says. But after a jury awards substantial damages to a client, and then the jury is asked by clear and convincing evidence, did Jeff Anderson act in a way that constituted willful and wanton disregard for the rights and safety of ATI? And the jury said yes. And then the jury was asked, was it directed specifically at ATI? And the jury said, yes. And then the jury was asked, how much do you award? And the jury said, 0. And I point that out because not just the novelty of when will we see that again, maybe the court sees that all the time, first time I have. But I pointed out to say, this jury listened to the evidence, listened to 5 weeks of testimony, listened to witness after witness after witness, and concluded that Lori was as much a part of this as FabCon, as was Jeff. And the court said as a result, trial court said as a result, Lori and FabCon are jointly and severally liable.
I'm confused. I thought they said the conduct wasn't specifically directed.
Your Honor, if I misspoke, I'm having a little trouble with my technology. If I misspoke about that, I apologize, and that may be the case. I know for sure that the jury found the first question in favor of ATI. Thanks for the clarification. Thank you.
Thank you as well, Mr. Ballard. Mr. Gardner.
May it please the court. Chief Justice Cady, very nice to see you, Your Honor. Justices, Justice Christensen, welcome. This is my first argument with you, and I have been up here a few times over the years, so I'm very honored to get to argue with you in the courtroom. Response to Mr. Ballard. I've been married 35 years this June. My wife's never asked to come watch me, either in the district court or the Court of Appeals or the Iowa Supreme Court. And the other thing that struck me when he was talking about wives is that Mr. Ballard and I have been involved in this case for almost half of his marriage. Almost a decade now. It all started back in 2011. My name is Stephen Gardner. I'm from Denise Gardner and Zing from Tumwa, Iowa. I represent Jeff Anderson, Lori Anderson, and Fabrication Construction, Inc. I will call it FabCon from here on. But based upon the questions that were asked of Mr. Ballard, as he indicated, we didn't know exactly what issues the court desired to address. Based upon the questions, I'm going to concentrate on the issues raised by the questions, that is the conspiracy verdict that was entered at the district court and that was reversed by the Court of Appeals. The Court of Appeals decision is well-reasoned, extremely well-written, and unanimous. And I think that should carry some weight. It is so well-written that I don't have any ability to argue it any better than the opinion as written. But my argument concentrates on exactly the same issues that the questions raised in response to Mr. Ballard's argument.
Well, let me first ask you this question then about the Court of Appeals opinion. Is it true that everyone in a civil conspiracy has to be or has to commit the underlying tort?
I don't believe so.
That's response.
I don't believe so.
All right, well, what was the Court of Appeals rationale that didn't they conclude that it was Jeff that committed the interference with prospective business advantage, and that did not relate to the conspiracy that they had entered into, because that conspiracy was something involving the appropriation of funds or
Exactly.
projects?
I think the simple explanation of the Court of Appeals decision was that in the conspiracy finding by the jury, and I agree with Mr. Ballard, I'm a big fan of the jury system, the jury found that the conspiracy involved the appropriation of funds and projects. In other words, they could have conspired to try to do that, and I'm going to come back to that point. But that the torts for which Jeff Anderson was found to be liable and responsible did not involve the misappropriation of funds and property of ATI. He was charged with interference with prospective business relations and breach of fiduciary duty, whereas the jury found.
Yeah, but here's the problem I have with that. I'm just looking at the Court of Appeals opinion on the next to last page. The Court of Appeals said the jury was instructed that a breach of fiduciary duty also included the misappropriation of profits, property, and business opportunities of one's employer. So that fell within breach of fiduciary duty. Jeff was found liable for that and was ordered to pay $336,000. And so why couldn't that have fallen within the scope of the conspiracy, where it appears the jury intended to award something? We don't know how much, but it said zero duplication, so something. Where am I missing your point?
I'm making the point that I think that's what the Court of Appeals held, that it did not include the misappropriation of funds and property.
But as instructed, it did. It said the jury wasn't, I'm just reading from the Court of Appeals. The jury was instructed breach of fiduciary duty included misappropriation of property, profits, property, business opportunities, and trade secrets of one's employer. The instructions limited the scope of the conspiracy to the appropriation of funds and projects belonging to ATI. Why aren't those one and the same?
I can't explain that. I can't explain the discrepancy there in the Court of Appeals decision.
I can't either, and that's somewhat diminishes the persuasiveness of it to me
Okay.
in reviewing the matter.
Well, wasn't there quite a bit of circumstantial evidence that, Lori was a bookkeeper and she was using the email of Confab to send projects in that direction instead of keeping them with ATI? Wouldn't that all sort of be the underlying evidence that would help support the interference of a prospective business advantage when you're funneling business away from one entity in the direction of another?
There isn't any question that there was evidence that she was using the ATI email for both her work as an ATI employee and as a Fabcon employee, and that would be circumstantial evidence. I agree. But we got to go back to what the jury found. What do we have on that page? And this goes directly to what Justice Mansfield said. The jury verdict for conspiracy was 0. And it said duplication. Now the question is, what does 0 duplication mean? Well, we had 4 claims in this case by ATI. Conversion. What's conversion? The taking of property of another. The taking of property from ATI. What did they award? 0. 2 more, they awarded substantial damages for interference with prospective relations, and the third one was for breach of fiduciary duty. The last one was for misappropriation of trade secrets. And how much did they award for misappropriation of trade secrets? 0. Now, how are we supposed to conclude that the use of the word 0 duplication applies to the 2 verdicts for money damages versus the 2 verdicts for 0? Justice Mansfield said it had to be for some amount. I tend to disagree. It could have well been 0 for the conversion because it's for conspiracy to convert property.
Well, and projects too.
And projects.
Well, would projects be something broader than the appropriation of funds?
It could be or it could not. But how do we decide where the 0 applies, to 1, 2, 3, or 4?
Well, how about the order of the questions that were asked? Question 38 said, did Jeffrey commit any of the wrongs of conversion, et cetera, et cetera? Jury says yes. Did Lori and Confab participate in a conspiracy to appropriate funds and projects? Yes. Was ATI damaged? Yes. What were the damages? Duplicative.
They could have, but they'd also awarded 0 and 0 on 1 and 4. It could just as easy. On question 38, it's did they commit the wrongs of conversion, interference, prospective business advantage, breach of fiduciary duty, or misappropriation? Their answer is yes. But there's only 2 of those that they awarded damages for. Then they go on to say that the damages for what they find the conspiracy for was 0, duplication. In this case, the problem is by post-trial ruling, the district court, unilaterally, at his own discretion, decided which count to apply the conspiracy finding to.
Are you arguing that the jury would have had to be instructed as to conspiracy as to each one of those torts?
It would have been the only way we would have known how they were finding the conspiracy occurred, whether it applied 1, 2, 3, or 4.
Unless the conspiracy was broad enough to cover all of them, and then would it make any difference?
If the conspiracy, how do we know whether the conspiracy was broad enough to cover all of them? We do not. All we know is they said there was a conspiracy to do at least one of these things. And how do you decide which one to apply it to? But in this case, the district court says, well, I'll just apply it to the damages.
Mr. Gardner, let's say hypothetically we conclude that what probably should have happened in this case, and I realize it's not necessarily realistic with a sealed verdict, you're both in your law offices and you get a phone call and the judge has you on the line. But what realistically should have happened maybe was the jury should have been sent back to clarify what it meant by this special verdict on question 41. Who bears the consequence of that?
The one who requests that the 0 be changed to another number, which would be Mr. Ballard. I don't think we were in our offices. I think we were there. Oh, okay, I'm sorry. I can't remember. It's quite a while. It's quite a while ago. Sorry. But I believe that the burden on that should be on the party that's requesting the court to change it, or requesting the jury to change it. Because the jury very well could have come back and said, we meant that the 0 applied to the conversion and the trade secrets, because we found he violated the trade secrets, but we found there were no damages. So they could have found a conspiracy to help him appropriate the trade secrets, but they didn't get it done. That's why we didn't award any damages. We don't know. But in this case, it's purely our position that the court should only change a verdict in a post-trial motion when the intent of the jury is clear. And in this case, the intent of the jury was not clear at all. That's all I have. I appreciate your time.
Mr. Gardner, thank you as well. Mr. Ballard.
Thank you, Your Honor. May it please the court, Mr. Gardner. So I think the point that maybe I would make with respect to the questions, well, how do we know what the jury was thinking? How do we know the jury meant that the conspiracy that the jury found extended to all of the damages that the jury awarded? I think there's, the first point that I would remind everyone of is that there was a trial judge that sat on this case who was asked post-trial to assess the jury's verdict, and particularly was asked to determine whether the conspiracy finding, the vicarious liability vehicle, extended to all of the jury's award or just part of it, okay, or none of it. And the judge who sat with the jury through 5 weeks of this trial said, no, it applies to everything, okay? So I think that bears mentioning, because if the judge had the concern or the question that, hey, I don't think the jury found conspiracy with respect to everything, the judge could have said something about it or done something about it, certainly, and the judge did not, okay? The second thing I would say is that, again, the evidence in this case, Lori's participation, you know, there's evidence that Jeff would tell Lori, Jeff wears a hat as the CFO of ATI, and then he wears the hat as the sole owner and manager of FabCon, and a check would come in, and because of the confusion in the marketplace, you know, we had witness after witness from places like John Deere and Whirlpool Amana and Riverbend Plastics say, yeah, we didn't really know. We called the number. We weren't sure if we were talking to ATI, if we were talking to FabCon. Well, sometimes checks, money came in. And Lori and other people in the office didn't know, does this money go to FabCon or does this money go to ATI? And who would Lori ask? She'd ask her husband. She'd ask Jeff. And then she would do what Jeff said, right? She was an active participant in everything that went on. You know, as I said earlier, I don't want anybody to lose track of the fact that, you know, one of the things that happened in ATI's history was there was this massive flood. You know, the city of Fairfield drained its water tower and didn't account for the pressure, and huge water pipe runs straight under ATI's concrete floor, bursts, pushes up everything, and so all this rigging, all this equipment that ATI stored needed to be moved off-site so repairs could be made and then could be moved back. ATI said to its insurance company, that's what we do for a living. We move equipment like that. We'll move it. Pay us. Don't pay our competitor to move our equipment and move it back. And the insurance company said, let's talk. But that's not what Jeff told Dean. Jeff told Dean, the insurance company said they won't let you move your equipment. Okay? We had 2 witnesses from Cincinnati Insurance who both said, we never told Dean that. Excuse me, we never told Jeff that. But that's what Jeff told his brother. And I mention that because what happened was Jeff had agreed, look, I'll do it through my other company. I'll do this work. I'll borrow your employees, and then when we get the money, I'll pay ATI. Like I said, he's got in charge of the books. He's the CFO here. He's the owner there. That money came in. So when the court talks about prospective relationships or future hoped for benefits, but not present funds and projects, I want to say, what about the $350,000, $400,000 in insurance checks that actually came in to FabCon that Jeff said he was going to pay over to ATI, but he never did? That is a real dollar damage. The jury was asked, you know, where we would have a problem is if the jury said how much damage was caused by the conspiracy, and the jury said 776. Well, then was that the same 776, or is that an additional 776? Might get stickier if the jury said 200. So then do we have a $976,000 verdict, or do we have 776 against Jeff and 200 of that against Lori? You know, the jury, as I said, the jury followed the instructions. The instructions told the jury, do not allow amounts awarded under one item of damage to be awarded under another item. I think the language of the instruction is, you shall not duplicate damages. The jury didn't. It said, we're not going to award additional damages here. That would be a duplication. Did Lori conspire? Yes. Did it harm ATI? Yes. How did it harm ATI? In the way that we awarded damages against Jeff. Based upon the court's conspiracy and vicarious liability law, Your Honor, we ask that the court reverse the Iowa Court of Appeals and affirm the judgment of the district court. Thank you for your time this afternoon.
Mr. Ballard, thank you as well. Mr. Gardner, thank you again. The case is now then submitted, and we'll next hear the arguments in Ashenbrenner.